Hi everyone, my name is Dharmendra Singh and I'll be teaching you polity for the upcoming UPSC mains exam. Our topic of discussion for today is salient features of Indian Constitution. First of all, let us discuss why we are going to study this topic. The relevance of this topic can be understood from the perspective of PYQs. UPSC has asked few questions from this simple topic. So let's see the questions. So in 2019 mains, UPSC has asked a question: what can France learn from the Indian Constitution's approach to secularism? So here they have connected the feature of secularism of Indian Constitution with that of France. And another question they have asked in the year of 2017. The question was: examine the scope of fundamental rights in the light of the latest judgments of the Supreme Court on right to privacy. Since in 2017 UPSC has asked this question because Supreme Court has given a judgment known as K.S. Puttaswamy judgment. In that judgment, Supreme Court has declared that right to privacy will be a fundamental right under Article 21. So, by taking that context, UPSC has asked this question. But both the questions have make us aware about the important features of Indian Constitution. So, because of all these questions, and UPSC has also asked many questions in prelims that we are going to see in our upcoming lecture. So let us start this topic. So our topic is important or salient features of Indian Constitution. So what we are going to study under this topic: first we will study the borrowed feature, then we will study the lengthiest written constitution, then we will study a comparison between rigid and flexible constitution. After that we will see parliamentary form of constitution. Then we will study about the judicial supremacy or parliamentary sovereignty, what is the difference between the two. Then we will study about the integrated judiciary and independent judiciary. India is having both type of judiciary. India is having integrated judiciary. Why integrated judiciary? Because district court, above that high court, and above that Supreme Court. Second thing, Indian judiciary is independent because executive and legislature cannot interfere in the workings of Indian judiciary. Say eighth, we will study about the fundamental rights, DPSPs, and fundamental duties. Then we will study about secular state, which type of secularism India is following, whether it is positive secularism or this is a negative secularism. Then we will see. After that, Indian Constitution is also having a special feature of universal adult franchise, under which India provide right to vote to all citizens, irrespective of their religion, region, language, but they must be above 18. So those who are above 18 years, they are having a right to vote. After that, we will be studying about single citizenship. India is not allowing dual citizenship. For example, if you are a part of Indian Union, for example, I am living in Madhya Pradesh. So I need not to take citizenship of Madhya Pradesh then to India, because India is having only one model of citizenship. If I am an Indian citizen, then I will automatically become the citizen of Madhya Pradesh. Then we will study about the independent bodies. After that, we will study about emergency provisions. Here we will study three provisions: 352, 356, and 360. Under 352, we are having a national emergency. Under 356, we are having a precedent rule. And under 360, we are having a financial emergency. Then we will study about three tier of government. Under this, we will study about the central government, state government. Then we will study about local bodies, PRIs or urban local bodies. Then we will study about cooperative societies. For example, Amul. Amul is also an example of cooperative society only. Then we will study the criticism of our constitution. Why our constitution is criticized, that we will see. After that, we are going to see some PYQs, both prelims as well as mains. As I have already made you clear, UPSC has asked two questions, one in 17, another in 2019. So because of that, salient features of Indian Constitution topic has become extremely important. So now let us start our topic. So first, Indian Constitution is a borrowed constitution. Why we are saying our constitution is borrowed? Indian constitution is a borrowed constitution because Indian constitution has taken several features from the constitution of different countries. Second, India has also taken or simply copied features from 1935 Act. That is why we are saying Indian constitution is a borrowed constitution. India has borrowed so many things from Government of India Act 1935. First, Government of India Act 1935 provide us a blueprint of our future constitution. Second thing, federal scheme. In federal scheme, we are having a state and center, their relations, how their relations will be governed. All things has been already explained in Government of India Act 1935, which we have directly copied from this act. Then Public Service Commission. In this we are having UPSC and state PSCs and joint PSCs. These are the provisions introduced by British government first in Government of India Act 1935, and we are also having the same provisions in our constitution. The same provisions have been copied from again Government of India Act 1935. Then judiciary, integrated and independent judiciary. The feature of integrated and independent judiciary has been taken from Government of India Act 1935. For the first time, Supreme Court was known as Federal Court at that time. So we have taken the same thing from the Government of India Act 1935. Okay, so this feature also we have taken from Government of India Act 1935. Office of Governor. How governor should act? What are the powers of governor? Whether governor will be executive head or artillery head, what type of powers the governor will have has already been explained in Government of India Act 1935. We have just copied them from Government of India Act. Then residuary power. Now we know residuary powers are with the central government. But in Government of India Act 1935, it has been clearly defined that residuary powers will be with Governor General. But we have just changed it, थोड़ा सा चेंज किया हमने and provided this power to central government. Okay. Then emergency provisions like Article 356, 352, Article 360. All these provisions have been taken from this Government of India Act 1935 only. Then division of power. Division of power between whom? Division of power between center and state. Center will be having a exclusionary power over union list, and state will be having power over state list, and concurrent list will be jointly governed by center and state. Center and state both will be having power over concurrent list. But in case of contrast, in case of differences, the law of central will prevail over the state. Okay, so this division of power has also been taken from Government of India Act 1935. Then bicameral legislature, yeah, bicameralism. Bicameralism simply means state legislature will be having two parts. One is state legislative assembly, another is state legislative council. So both the features we have drawn from Government of India Act 1935 only. Then administrative details like IAS, IFS, IPS. At that time they were known by different names. Civil servants were known by different names. Okay, so all these administrative provisions have also been taken from Government of India Act 1935. Then interim constitution and structure of the constitution. Interim constitution was provided for the governance of interim government. Interim constitution was nothing but just Government of India Act 1935. So this Government of India Act 1935 contributed significantly in the preparation of our constitution. Next, we will be seeing features of Indian constitution from the USA. So what features we have taken from USA? First, power of judicial review. We have taken it from USA. What judicial review means? Judicial review means Supreme Court or High Court can introspect whether the law of legislature is in consistent with the constitutional provisions. So this power is only vested with Supreme Court or High Court. They can judge whether the state law or central law is in line with the constitution. If it is in line with the constitution, then it's all right. But if it is contrasting, then Supreme Court or High Court has power to declare that particular law as null and void. So this judicial review power we have taken from the Constitution of USA, because the same power is having USA judiciary. In simple terms, the judiciary of USA can also declare any law of Congress, their parliament known as Congress. So they can declare any law of Congress as null and void if it violates USA Constitution. Then preamble, we all know about preamble. Our constitution starts with preamble, with the people of India having solemnly resolved to constitute India into a solemn republic, or all these things. So the nature of constitution we have taken from USA Constitution, especially the words "we the people." We the people we have taken from the Constitution of USA. Although the original idea of preamble was taken from objective resolution. Objective resolution was proposed by none other than Pandit Jawaharlal Nehru. Okay. Then independence of judiciary. Judiciary will be independent. Executive and legislature will not going to interfere in the workings of judiciary. Has also been taken from the Constitution of USA. Then post of vice president. In USA, there is a president, and under whom there will be vice president. For example, if you will see the present president Donald Trump, under whom there is a vice president. Similarly, in India also, we are having a president Draupadi Murmu, under whom there is a vice president known as Jagdeep Dhankar. So this nature of president and vice president we have taken from the Constitution of USA. Then procedure of impeachment of president. This simply means how we are going to remove president from office, judges from office, or high court judges from office. So the nature of removal of judges, judges of Supreme Court and High Court from office, president from office, has been taken from USA. How we are removing judges? Simply a proclamation, or a simple terms we can say, a bill has to be passed in both the houses of Lok Sabha and Rajya Sabha. So we have to pass a bill to remove our president, vice president, or president, judges of Supreme Court and High Court. But before removing that through the parliament, first we have to form a committee that will inquire if any charges against them. If that committee says okay, you can go ahead with that, then parliament will go ahead with the same. Okay. The next provision is, let me clear it. Next provision is fundamental rights. We are having fundamental rights from Article 12 to 35. Okay. So we are having fundamental rights from Article 12 to 35. These fundamental rights for the first time was introduced in the Constitution of USA. So we have taken it from the Constitution of USA. Then written constitution. Actually, the idea of constitution was first proposed in UK, but UK was not having a written constitution. So they are not having written constitution. It was the USA. It was the USA who is having the first written constitution. So the Constitution of USA was written at that time. So because of that, it became a first written constitution. So India has also inspired from the British Constitution and taken this feature. Okay. So our written constitution has been inspired from the Constitution of USA. Then next, vice president will be the ex officio chairman of Rajya Sabha. Or in simple terms, we can say our vice president will be the ex officio chairman of upper house. Our vice president will be the ex officio chairman of upper house. This feature is already included in the Constitution of USA. So we have copied this provision from the USA Constitution. Okay. So I think things should be clear. Then president being the supreme commander of armed forces. In India, President is the highest commander. President will be above army, navy, and air force. Okay. So army, navy, air force, all these three wings are having their heads. Above that is CDS. CDS is heading all these three, and above that is president. So president is ultimately the head of all the forces, both in India and USA. India has copied this provision from the Constitution of USA. Next we are going to see which features we have copied from the Constitution of Britain. We have taken so many features from Britain. For example, parliamentary form of government. Remember one thing, India was ruled by Britain. So ultimately we are going to so much influenced by Britain. Since it was Britishers who introduced the idea of parliament, so we are ultimately going to be influenced by this provisions. Okay, so parliamentary form of government has been taken from the US. Then cabinet system, you all know, at state and central level we are having cabinet ministers. So this nature of cabinet has been taken from USA. Okay, in India, Britishers in 1861 introduced this cabinet type of thing. Okay, where everyone is responsible for a specific department. Then rule of law, this provision has also been taken from USA. Under rule of law, we simply understand there should not be anything above the law. Law must be the guiding force, none other than this. Okay, anything other than law cannot guide you, cannot decide the verdict. Okay, then single citizenship we have taken from USA. Bicameral legislature, for example, we are having Lok Sabha and Rajya Sabha. So we are having two houses. So this provision we have also taken from USA. Sorry, Britain. Law making process, how the law should be made. We already know in India laws are made through the parliament. This provision we have taken from again Britain. In Britain also, if any law has to be made, then that law must be passed through parliament. Then parliamentary privileges. In parliament has certain privilege. For example, anything can be said or uh, written about anything. For example, if I am a member of parliament, I can say anything. Nobody is going to punish me for that. For example, I am a member of opposition, so I can criticize government to any extent. Government is not going to jail me. They are not going to say, no, you have said this, so you are going to be jailed. So parliament cannot compel us. Okay. Then prerogative writs. We are having 5 writs like mandamus, certiorari, then quo warranto. So these writs has been taken from the Constitution of Britain. Then the post of prime minister. Prime minister will be the real head of government. This provision has also been taken from USA. Sorry, Britain. Remember one thing, in Britain, king is a titular head. King or queen is a titular head. In India, president is a titular head. Similarly, in India, president is a titular head, but prime minister is a real head because real powers are vested with the prime minister. Then we have already discussed it. Nominal head of the state will be president. This provision we have taken from Britain. Then office of speaker. Speaker will be the guiding force in Lok Sabha. This provision we have taken from the Constitution of Britain. Then lower house will be having more powers. For example, budget can only be introduced in the lower house of parliament. Parliament cannot withhold, for example, Rajya Sabha cannot withhold finance bill or money bill for more than 14 days. So because of that, lower house of parliament, which is known as Lok Sabha, is having more power than the Rajya Sabha. This provision has also been taken from Britain. Then council of ministers will be collectively responsible to the lower house of parliament. For example, in India, If Prime Minister has to prove his confidence, then he need not to worry about Rajya Sabha. He had to worry about only Lok Sabha. If he is having numbers in Lok Sabha, then he will be the Prime Minister. But if he is having numbers in Rajya Sabha, but not in Lok Sabha, then he may not remain the Prime Minister. Because the person who is having majority in lower house will be the king, will be the real power holder in case of India. Next, we are going to see Irish Constitution. What provisions we have taken from Irish Constitution? So we have taken DPSPs, Directive Principles of State Policy, from the Constitution of Ireland. In Indian Constitution, we are having Article 36 to 51. So Article 36 to 51, we are having the provisions of DPSPs. DPSPs are the guidelines for the governments in their policy formulation. So how government should formulate their policies will be decided by the DPSPs. They are not bindings on the government. Remember this. They are not binding. You cannot force parliament, you cannot force government to follow or to implement DPSPs because of the resource crunch. Government is having a resource crunch, okay, and they are having economic features, so we cannot force our government for doing that. But we have taken this from Ireland. Then nomination of members of Rajya Sabha, we are having 245 strength, and out of that 12 members are nominated from different fields by president, and this provision we have taken from Ireland. Then how president should be elected? We elect president through the system of proportional representation. This provision we have copied from the Constitution of Ireland. So we have copied this provision from the Constitution of Ireland. So these are the features which we have taken from the Constitution of Ireland. Now let us see next. Next is Canadian Constitution. So from Canadian Constitution we have taken several features like federation, in which center will be having more power. In Indian Constitution we are having a federal system, but in our federal system central government is having more powers than the state. So this provision we have taken from the Canadian Constitution. Then appointment of governor by the center. In India, the governors of state are appointed by the central government. In Canada also, the governors of states are appointed by the central government. So we have copied this provision from the Canadian Constitution. Then residuary power to be vested in the center. We have also taken this provision from the Canadian Constitution, because in Canada residuary powers is with central government. Then Supreme Court will be having advisory provision. This provision has also been taken from Canada. Under this, president can take advice of Supreme Court on any matter. Remember this. President of India is having power to ask Supreme Court's opinion on any matter. Okay. So this provision we have taken from the Constitution of Canada. Next we are going to see Australian Constitution. So what features we have taken from the Australian Constitution? So first feature which we have taken from Australian Constitution is joint sitting of Parliament. In India, if there is a suppose there is a problem in passing any bill, because both the houses are not agreeing. For example, Lok Sabha has passed the bill, but Rajya Sabha is not agreeing that bill. Or for example, Rajya Sabha has passed the bill, but Lok Sabha is not agreeing, and government consider that bill is extremely important. So because of that, there is a difference of opinion between both the houses. So to remove that difference of opinion, our Constitution is having a provision of joint sitting. In joint sitting, this joint sitting will be headed by the Speaker of Lok Sabha, and now the majority will decide whether the bill will be passed or not. In the case of India, we are having this joint sitting thrice. One in for Dowry Act, another for I think Quota Prevention of Corruption Act, and another in 2005 also. Okay, so three times we are having joint sittings. So joint sittings are always happen for disputes, because there is a dispute between both the houses. One house is passing the bill but another house is rejecting that. So because of that, there is a situation of uh, एक प्रकार से हम ये कह सकते हैं कि एक ऐसी सिचुएशन बन जाती है जहां पे वो बिल ही पास नहीं हो रहा है, बट गवर्नमेंट नीड्स दैट. Okay, so we have taken this provision from Australian constitution. Then freedom of trade, commerce and intercourse. In India, you are free to do your business. There is no uh, there is no specific provisions for trade or commerce or intercourse. If, for example, if you are born in Maharashtra, then you cannot trade in Gujarat. So there is no restriction like that. So this provision we have taken from Canada. Then idea of concurrent list. Concurrent list is having provisions that are important for both center and state. That is why both are having powers related to the matters of concurrent list. But in case central government made any law, then the law of central government will prevail over that issue. For example, recently passed I think Muslim personal law board का जो bill है, that also comes under concurrent list only, since central government has passed that bill. So there is no state that can overcome that bill. Okay, so this provision of concurrent list we have taken from the constitution of Australia. Now let us see the more features. Weimar constitution. Weimar or Germany. Weimar is none other than Germany. Germany, earlier known as Weimar. So from Weimar constitution we have taken the provision of suspension of fundamental rights in case of emergency. For example, there is emergency under article 352, then fundamental rights are automatically suspended in India, except few. For example, except the fundamental right of article 21, right to life. So except this, almost all fundamental rights are suspended. So this type of methodology we have copied from the constitution of Germany, because Germany is having this provision. Next is France. So from France we have taken a republican system. Republican system simply means head of the state will not be from a particular caste, religion, region, lineage, descent. So head of the state will not be from a particular caste, family, religion, region, lineage. Okay, and head of the state will be elected, not the selected. He should not be selected, he should be elected. So we have taken this provision from the constitution of France. Then principle of liberty, equality and fraternity, which are enshrined in our preamble. So we have taken all these three features from the famous French Revolution. So we have copied these three golden words from French Revolution of 1789. Okay, now let's see more features. USSR, now Russia. What we have copied from the Russian constitution? So Russia is having a provision of fundamental duties, none other than communist countries, because communist countries are having a concept of fundamental duties. Democracies are not having a concept of fundamental duties. So we have copied the concept of fundamental duties under article 51 subclause A from the USSR constitution or Russian constitution. Then the ideals of justice, social justice, economic justice and political justice, which we are having mentioned in our preamble, has been taken from USSR. Social justice means government will ensure that there must not be any social inequality on the basis of caste, religion, region. So these type of inequalities must be avoided. Then government will make sure that there must be minimum economic, inequality. There must be minimum economic inequality. Government will also ensure that political equality should be there. Everyone must be having the right to contest elections. To fulfill this provision, government has brought 73rd and 74th Constitution Amendment Act, and under this they have provided a specific reservation for SC and ST, and it is up to the state governments that they will decide the reservation of OBCs. But SC, ST and women reservation has been clearly decided by the parliament. Okay, so this is how they are going to ensure political justice. Now let us move on to South Africa. So what we have taken from South Africa, how the constitution should be amended. So this procedure of constitutional amendment we have taken from South African constitution. For example, in India, if we want to amend any provision, that has to be go through Lok Sabha, Rajya Sabha, and in some cases that should be passed by states also. And remember, assent of president is also necessary. So this is the process of constitutional amendment which we have taken from the constitution of South Africa. Then election mechanism of members of Rajya Sabha. In Rajya Sabha, we elect our member through the proportional representation. And who participate in these elections? Representative of legislative assemblies. So this type of method of elections of the members of Rajya Sabha has also been taken from the constitution of South Africa. Now let us move on to the next provision, Japan. What we have taken from Japan? So we have taken this provision, procedure established by law, which simply means if anything has to be done, then the procedure for that will be decided by the law. What procedure has been decided, defined in the law, that has to be followed. Whether the person is a normal citizen or a VIP, both will be having the same procedure. For example, there is a challan of a car, and if this car belongs to a normal citizen, then also he has to go to a office and deposit the challan. And if the car belongs to a president of India, then also he has to go to the concerned office and deposit that. Okay, so this shows that the procedures established by law must be followed, which we have taken from the constitution of Japan. Next feature. So first feature we have already seen. First feature of Indian constitution was Indian constitution has been borrowed from so many constitutions. Now let us see the lengthiest constitution. Indian constitution is lengthiest constitution. Why? Because Indian constitution is a written constitution. We have almost included everything in our Indian constitution. First written constitution was USA, but first constitution was UK. In Indian constitution we are having a preamble, 395 articles, 22 parts, 8 schedules. So just look at it. So many provisions. So because of that we are having so many articles, and it increases the size of our constitution. Presently we are having a preamble, 470 articles, 25 parts, 12 schedules, 5 appendices, and 100 almost 7 amendments. Okay, so these many things we are having. Because of that our constitution became lengthiest constitution. Length of our constitution has increased because of this. Next, so we have seen two features. One is borrowed constitution, another is lengthiest constitution. Let's understand the reasons for lengthy. Why our constitution is lengthy? Because we are having so many provisions. First, vastness of our geography. India is having a vast geography, and we have to accommodate that geography in our constitution, and because of that length increases. We have taken so many provisions from Government of India Act 1935 and included that, and because of that also length increases. Single constitution for center and state, and because of that many provisions has to be included for center and state, and length increases. Then lawyers paradise, because the language of our constitution is very difficult, and this difficult languages increases the size. Then social and cultural aspects. Indian constitution is having so many social and cultural aspects, and because of that, size increases. Then administrative details have also been included, and this also increased our size. Okay. Now let us understand the next feature, that is various sources. Indian constitution has been taken from almost studying of all resources. For example, as has been said by famously said by Dr. B.R. Ambedkar, India has ransacked all non-constitutions, which simply means India has studied almost all constitutions and taken out important provisions from that. Okay. Then we are having a structural part government of India 1935. Then our philosophical part has been taken from USA and Ireland. Then political part has been taken from British constitution, which we have already studied. Then the third feature of Indian constitution is rigid and flexible. When it comes to rigidity, some features of Indian constitution are very rigid. It is very difficult to amend them. For example, fundamental rights, federal features. So it is very difficult to amend them. On the other hand, some features are very flexible. For example, if you have to change the name of state, it is very easy to change. So Indian constitution is a mix of both flexible and rigid constitution. Rigid constitution is USA and flexible is British. India is having a blend of both. Indian constitution can be amended in the article 368. Other provisions of the constitution, remember one thing, except federal features and fundamental rights, other features of the Indian constitution can be easily amended. Okay. Next feature of Indian constitution is federal versus unitary, whether Indian constitution is federal or unitary. Indian constitution is federal because of these many provisions. India is having a two level of government. One is central government and state government. Now we are having a three level of government, local bodies. So three tier of government made us federal government, made our features federal. Okay. Then seventh schedule. Seventh schedule has union list, state list, and concurrent list. So this makes our constitution federal. Then our constitution is written. So this also makes our constitution federal. Then supremacy of constitution. Constitution will be supreme in all matters. This also made our constitution federal. Then rigidity of constitution. Constitution cannot be easily amended. So this provision also made our constitution supreme. Then independence of judiciary. Judiciary will not be under executive or legislature. It will be independent of the both. This also makes our constitution federal. Then Rajya Sabha and Lok Sabha. Rajya Sabha will be the representative of state and Lok Sabha will be the representative of people. So this makes our constitution federal. So these many provisions of our constitution makes our constitution as a federal features. Okay. So because of these provisions, we can say Indian constitution is federal. But there are some provisions which makes our constitution unitary. Because of them, there is a question over the federal features of Indian constitution. For example, India is having a single constitution, but most of the federal constitutions of the world are having two constitutions. One is for center and another is for state. But in case of India, we are having the same constitution. So this makes our constitution a federal, not a federal, unitary. Then single citizenship. India is having a concept of single citizenship, which makes us unitary. Then flexibility of constitution. Indian constitution can easily be amended by the parliament. So in simple terms, federal features can also be amended by the parliament. So this makes our constitution unitary. Then appointment of governors. And who are the governors? Governors are the agents of the central government. They work on the behalf of the central government. So this makes our constitution also unitary. Then integrated judiciary. There will be a state, then आपका central, at state level high court and central level supreme court will be there, and this is integrated. Supreme court is above high court. So this also makes Our constitutional features unitary. Then all India services, IAS, IPS, IFS, they are recruited by the center, but they work in the state. So this also make our constitution unitary. Then emergency provisions under article 352, 356 and 360, all these emergencies can be implemented by central government. This also makes our constitution unitary. Then president rule under article 356, only central government can impose president rule without the consultation of state government. So this also makes our constitution unitary. Let us see another features of Indian constitution. So this we have already seen, united union of states, not a federation of states. This debate we will discuss in our upcoming chapters. Okay. Then federal in form of unitary in spirit. So yeah, this has been said by KCBRA. So these are the comments related to the federal features of Indian constitution. For example, Morris Jones said Indian federalism is a bargaining federalism. Granville Austin said cooperative federalism, whereas Ivor Jennings said federation with a centralizing tendency. So this we will study in our upcoming lessons. The next feature of Indian constitution is parliamentary form of government. Parliamentary form of government simply means India is having a Westminster monarch, which means executive means government ministers. Government ministers will be drawn from the parliament. Government ministers will be drawn from the parliament. Okay. Then prime minister will be the head of the government. This is also an important feature of parliamentary form of government which we are having. Then Indian parliament, not sovereign but Britain is. This simply means in Britain whatever parliament said that is supreme. But in India whatever parliament said is supreme, but still Supreme Court is having power to decide whether this will be supreme or not. So any amendment done by the parliament can be amended by the Supreme Court. So because of that, we cannot say Parliament of India is supreme. In India, people are supreme. People are supreme. Okay. Then elected head, but monarch in Britain is not elected. For example, in case of India, we are having the elected head in the form of president. But in Britain, king or queen is titular head of the government, and they are not elected. They are from a particular lineage. Then features at center and state level. For example, features are almost same. Nominal and real executive at state and central level. At state level, nominal executive will be the governor, and real executive will be the chief minister. Majority rule at state and central level. Majority party will rule. Then PM and CM will lead the coalition. Lok Sabha and Vidhan Sabha can be dissolved, and membership of ministers in legislature, and no one can become a minister without having membership in the concerned state legislature. Then collective responsibility of executive to the legislature. This is absolutely correct. For example, in case of India, if anything has to be done, then that thing must be explained in the concerned house. So this is a special feature of Indian constitution. Then judicial supremacy versus parliamentary sovereignty. India is having both. India is having a parliamentary sovereignty in few matters, but in few matters, judiciary can overreach the powers of parliament. For example, parliament is having a power to amend the constitution. Parliament can amend any portion of the constitution. There is no ban on parliament. Second thing, Supreme Court is also having a power to declare any law unconstitutional if it violates basic structure doctrine. This basic structure doctrine has been declared in 1973, and the law and the judgment was Keshavananda Bharati. In Keshavananda Bharati judgment, Supreme Court has clearly said that if any law violates the basic structure doctrine of Constitution, then that law can be declared null and void. Then next, if we talk about USA is having a judicial supremacy, because whatever will be said by the judiciary cannot be amended in USA. But Britain is having a parliamentary sovereignty. Then from procedures established by law to due process of law. India follows both. India is having a mix of both provisions. Then integrated judiciary simply can be understood from this diagram. In India, we are having a lower courts at district level or below that also. Then we are having high court. In any law, any decision of lower courts can be challenged or appealed in high court, and decision of high court can be appealed in Supreme Court. And this is an integrated system. So this provision which we are having, and remember one thing: all these three levels of judiciary, is integrated with the same center and state law. All are having the same power related to the laws of center and state. Next important provision of Indian Constitution is independence of judiciary. Why independence of judiciary? Because we are having some provisions like security of tenure of judges. Once a judge appointed cannot be removed except in few cases, and that few cases are very difficult to remove. For example, if you have to remove a judge, then a committee has to be formed, and after the committee inquiry, the whole process has to be done through the parliament or concerned state legislature, which is not a simple task. Fixed service condition for judges. For example, if you are appointed a judge at 1 lakh per month, you cannot diminish his salary by saying that we are not having finances. Then expense of Supreme Court charged on consolidated fund of India, which simply means whatever conditions are there, whether state is in war or is in any problem, salary of any employee can be cutted, can be deducted, but you cannot deduct a salary of a Supreme Court judge under any pretext. Then provision on discussion of conduct of judges in the legislature. Legislature cannot discuss whether the judge has taken a right decision or wrong decision. This power has been reserved for the judges only. Judges can discuss their correct things. Parliament cannot. Okay. Then separation of executive and judiciary. Judiciary cannot appoint, or simply we can say, executive cannot interfere in the workings of judiciary. For example, the appointment of judges will be decided by the collegium. And who is heading collegium? Collegium is headed by the judiciary only. 5 senior most judges. So parliament or state legislature or executive cannot interfere in the workings of judiciary. Ban on the practice after retirement. For example, I am a judge of the Supreme Court. I cannot practice as an advocate after my retirement in the same Supreme Court. Then contempt of court. If anyone is trying to defame the court, then court is having a power to punish that person for that defamation, which is known as contempt of court. And these provisions have been made in our constitution to protect the independence of the judiciary. Next feature is fundamental rights. We are having fundamental rights in part 2 of Indian Constitution from article 12 to 35. Reasonable restrictions have been imposed on grounds like sovereignty, unity, integrity. They are having 5 writs. We are having 5 writs which can be issued under article 32 to protect our fundamental rights. Then fundamental rights can be suspended in case of national emergency, but we cannot suspend article 20 and 21 because they are providing a person a simple right to life, so which we cannot suspend in any situation, even in the case of emergency under article 352. Next thing, directive principle of state policy. We are having part 4. This we have already discussed. Part 4, we are having DPSPs from article 36 to 51. We are having few DPSPs are socialistic, few are Gandhian, few are liberal, few are intellectual. Fundamental in governance of the country. They are very fundamental because governance of the state and center will be decided by these DPSPs only. They are aimed to establish India as a welfare state. They are non-justiciable, which simply means you cannot go to court for their implementation. Court cannot compel a person, compel a government to implement these DPSPs. Then they are extremely important because Supreme Court in its Minerva Mills case has said DPSPs are found on the balance of fundamental rights and DPSPs. Simply we can say our constitution has formed a balance through whom? Fundamental rights and DPSPs. Because fundamental rights are providing you political justice, whereas DPSP is providing our citizen an economic justice. And because of that, Supreme Court has commented this in Mineral Mills case 1980. Next provisions which we are going to study under this are fundamental duties. We already know our original constitution was not having fundamental duties. We have taken this provision from the constitution of Russia. Okay. So Indira Gandhi government formed a Swarm Singh committee, and this committee recommended the inclusion of fundamental duties. And to include this, government has brought 42nd Constitutional Amendment Act in 1976, and that added a part 4th A under Article 51A. Almost 10 fundamental duties were added at that time. Remember, in 2002 we have added one more fundamental duties. Because of that, total fundamental duties are now 11. Fundamental duties are reminder to citizens that they are having certain duties towards the nation. Okay, but remember this: if anyone is not following any duty, you cannot go to the court and asking that please follow this duty. So they are also non-justiciable. It is up to the citizens whether they are going to follow or not follow. Okay, so this is also non-justiciable part of the Indian Constitution. Next is secular state. Indian Constitution is having a secular state, which simply means India is not having any official religion. We cannot say India is a Hindu state, Muslim state, Christian state, because India is not following any religion officially. Second thing, India has already declared this in preamble by mentioning the word secular. India is a secular state. Then fundamental rights under 14, 15, 16, 25, 26, 27, 28, 29 or 30 has clearly mentioned that India is a secular state. For example, in 14, 15, separation or discrimination on the ground of religion has been clearly denied. When it comes to Article 16, no one can restrict you in any employment on the ground of religion. 25 to 28 provide everyone to process or profess. They can practice any religion from Article 25 to 28. 29 to 20, 29 to 30 provide religious minorities certain rights related to opening up of their educational institutions. Then we are having a Article 44 under which we are having a provision of Uniform Civil Code. So this also made India a secular state. Then we are having a positive concept, which simply means if India is going to provide financial assistance, then India will provide financial assistance to all. All the religions will be provided equal financial assistance in case of India. Okay, so these provisions make our constitution a secular state. Then universal adult franchise, we already know our original constitution was having a provision of universal adult franchise, but the age for voting was 21. During Rajiv Gandhi government, they have decided to reduce the age. So through 61st Constitutional Amendment Act 1987, they have decided the voting age from 21 to 18. Okay, so now anyone from any religion, from any caste, from any region can cast their vote if they have attained 18 years of age and they are the Indian citizens. Then next important provision is single citizenship. Remember this, like Britain, but unlike USA, we are having a single citizenship. USA is having a dual citizenship. In USA, a person has to take citizenship of state and center separately. But in Britain, if you are a citizen of Britain, then you are a citizen of state as well. Same in India. If you are a citizen of Delhi, then you are automatically a citizen of India. This provision of unitary citizenship has been brought to promote fraternity. For example, if I am living in Delhi, I need not to claim I am a Delhi citizen because everyone will be Indian only. So to promote fraternity or brotherhood among people, this provision has been introduced. Then to promote stop communal rights, class conflicts. So because of all these things, we have this provision of single citizenship, so that caste wars, linguistic clashes, and ethnic disputes can be stopped in a multi-diverse nation like India. Then independent bodies, we are having so many independent bodies, and they act as a check on the arbitrariness of various bodies of executive. Main democratic system and accountability of governance, they are formed for maintaining democratic system and accountability of government. For example, ECI ensures fair elections, CAG audit, UPSC fair recruitment, and because of that you are preparing for the exam. State PSC is done same for the state service exams, or simply we can say class 2 or class 3 exams. So these are the institutions which maintain the democratic fabric of our nation. Then emergency provisions, we are having some emergency provisions. National emergency can be imposed under Article 352. Remember this. This emergency has been imposed thrice. One during China war, another Pakistan war, and third, you all know, in June 1975. And because of that, we celebrate 25th June as Samvidhan Hatya Divas. Okay, so for the first time we celebrate Samvidhan Hatya Divas. So simply we cannot say celebrate, we simply say we must commemorate Samvidhan Hatya Divas on this year for the first time, because previously in 2024 our honorable home minister or home ministry has issued the notice about the same in July. Okay, so because of that we are celebrating this year. Then we are having a provision of president rule under Article 356. President rule can be imposed in state in case of failure of constitutional machinery. If any state government is not working as per the provisions of constitution, then president rule can be imposed in that particular state. Then financial emergency can be imposed under Article 366. But remember one thing, India has never imposed this financial emergency, although conditions has emerged in 1991, but India has not imposed financial emergency. Remember one thing, in case of emergency, India became unitary because all the powers of state came in the hand of central government. Then next is three tier of government. We have already discussed about it: central and state, center, state, and ground level democracies, PRI and municipal corporations. This we have already discussed. Then cooperative bodies. In 2011, government brought a 97th Constitutional Amendment Act 2011 and made cooperative societies a part of Indian Constitution. Now every citizen of India is having this fundamental right that they can form cooperative society. Second thing, promotion of cooperative societies has already been included in our DPSP. Okay. Then cooperative societies has been put under part 9th B. Parliament and state legislature is empowered to make laws related to cooperative societies. For example, state cooperative societies are governed by state laws, whereas interstate cooperative societies are governed by parliament. Next is criticism. These are the features of Indian Constitution which we have seen up till now. Now we are going to look at the criticism of Indian Constitution. So first criticism is Indian Constitution is legalist in a very legal language. Second is complicated. So Indian Constitution is very legal and complicated. So it is became a lawyer's paradise. If you have to interpret anything about the Indian Constitution, then you have to take the help of lawyers. So it's a lawyer's paradise. They are full just because of Constitution. So that is why it is referred as lawyer's paradise. Second, this is a bulky document, elephantine size. It is very difficult to read the whole Constitution. So it is very long in size. Third is un-Gandhian, because there are various provisions which are against the ideology of Gandhi. Gandhiji was in favor of making village republics, but this Constitution is having another story. Fourth, Indian Constitution is un-Indian. Why un-Indian? Because we have almost borrowed all features. We have borrowed almost all features from different parts of the world. So there is nothing in Indian Constitution. Indian Constitution is of name only. Then fifth criticism is Indian constitution is not a original constitution. It's a baggage of borrowing. We have borrowed everything. Then Indian constitution is influenced by British legacy because most of the provisions has been taken from Government of India Act 1935, and this is the major criticism of Indian constitution. So up till now we have studied about the features and criticism of Indian constitution. So what we have studied? We have studied the features in detail. Then we have studied the criticism. This can be used in answering mains question. Okay. What you can do? You can simply write a simple definition in your introduction. Then you can write features. Then you can include some criticism, and then you can conclude by writing the importance of Indian constitution in conclusion. Now let us discuss a few questions related to the prelims also. So these many questions has been asked by UPSC in their prelims exam. For example, first question is, which one of the following is not correctly matched? So which feature is not correctly matched? For example, fundamental rights, USA, this is correct. DPSP, Ireland, this is also correct. Residual power of center, this is Australia, but this is incorrect because we have taken this provision from Canada, not Australia. So this option is incorrect. So answer will be C. Then next question is the idea of concurrent list in the Indian constitution has been borrowed from, कहाँ से borrowed? USA? No. Switzerland? No. Australia or USSR? This is from Australia. Australia is having a concept of concurrent list. So we have borrowed it from Australia. Next is in Indian political system, which one is supreme? The Supreme Court, Constitution, Parliament, and religion. Because we are having the four options. In the four options, the correct answer will be B. Constitution is supreme in India. Then the idea of preamble has been borrowed in Indian Constitution from the Constitution of. So idea of preamble has been borrowed from USA, which we have already seen. Then who said India is a quasi-federal state? This we have already seen. Ivor Jennings have said the same thing. So these are the questions which we have studied up till now. Let me show you mains question as well, which we have studied in our starting. Just a bit. Okay. So these are the mains questions which we can also write by understanding the concepts which we have studied in our class. What features India or France can learn from India? So we have seen so many features. So you can write various features like France can learn positive secularism from India. France can learn how to maintain balance between center and state, single citizenship. So all these features can be learned by France from India. Then scope of fundamental rights in the light of latest judgment, right to privacy. So this we can also write by specifying the features of fundamental rights. Okay, so these questions must also be solved by you. So I hope the lecture will be fine for you, fine for everyone. So thank you everyone for attending this class.